Good afternoon and welcome to the Emerging Canadian Legal Issues and Considerations webinar. We will be starting the webinar momentarily. Please stay tuned and we look forward to starting shortly. Welcome to the Emerging Canadian Legal Issues and Considerations webinar. Thank you all for joining us. My name is Ryan McKenna from NFP's Marketing Department, and I will be your moderator for today's presentation. You may submit your questions using the Q&A function on your screen. We'll be answering the questions you send through the Q&A today, and we will try our best to answer all your questions by the end of the call. At this time, I will turn it over to Alicia Henderson, Senior Vice President of Benefits Services at NFP in Canada, to introduce the webinar and our speakers. Alicia, the floor is yours.
Thanks, Ryan. Good afternoon, everyone. Really want to say a big thank you to all of you who have taken time to join us today for what I believe is going to be a really informative session. Today is actually the last of our 3 fall seminars, and we know that there's no shortage of seminars and webinars and things that are coming your way. You've got lots of options to attend these sessions, so we really do appreciate you taking the time to be with us. We developed these sessions to be about 45 minutes of your day, as we know things are busy for each of you as you continue to focus on your business needs. And we also know COVID-19 has changed the landscape for so many employers. In the past, some of you may know, we've had Stephen from Hicks Morley and his team speak at a number of our events, and it's always been extremely well received. When we started to talk specifically about this session, what we were really trying to get at, or what I guess where my mind was, is what are the legal issues that you as employers are now faced with that you never dreamed that you would be faced with. And so I'm really excited about hearing from Steve and from Evon on some of these key issues. So whether it's infectious disease, emergency leave, some of the accommodation challenges that you're currently facing, I think we're going to learn a lot today. But as I am learning from the lawyers, this seminar is not legal advice, but just an update on some of the emerging issues. So let's dig right in. We are really lucky to have Stephen Goodwin and Evon Gayle from Hicks Morley with us. Because their bios are actually included in the invite, I'm going to provide just a really quick introduction to both of them because I really want us to get focused on what they have to share with us today. So do take a moment and read the impressive bio of these individuals. Stephen Goodwin is a partner at Hicks Morley, and he practices labor and employment law. He advises both public and private sector employers on all aspects of HR law. He has appeared before the Ontario Labour Relations Board, Workplace Safety and Insurance Appeals Tribunal, Human Rights Tribunal of Ontario. He's also been at labor arbitrations as well, and certainly in the courts defending wrongful dismissal claims. So lots and lots of experience. Evon Gayle is a labor and employment lawyer and advises employers on a wide variety of issues involving labor, employment, human rights and accommodation, occupational health and safety, as well as workplace safety and insurance. And he got his law degree actually on both sides of the border, but practices here in Ontario. Both clearly have a passion for what they do. And without further ado, I'm going to turn it over to Evon. Thanks for being with us.
Thanks, Alicia. Good afternoon, everyone. As Alicia stated, we're really happy to be presenting some employment law updates to the field. It seems to be having about 60 participants, which is great. We do have a lot of slides and a little time, so I'll just get right into it. Here we have the agenda. We'll start discussing some COVID-19 updates regarding benefits, leaves, and legislation. And then the latter half of our presentation will be discussing wrongful dismissal updates with the recent Waksdale case, which some of you may be aware of, and other litigation trends. Next slide, Steve. So we're going to start with our federal recovery benefits. Federal benefits such as the CRB, CRSB, and CRCB, you can see the full names on the screen, seek to help workers affected by COVID who, for instance, may be off on a provincial leave of absence, such as the IDEL. We've currently transitioned from the CERB to EI. The CERB ended on October 3rd. And to ease the transition to EI, the government has implemented some changes to the EI program, both to the eligibility requirements and to the minimum benefits available. I won't be discussing too much on that, which can be found on our website or through this recorded presentation. You will see links to Hicks Morley FTR Now, which will go more in depth to some of the topics I'll discuss. So with regard to the new EI eligibility requirements, just briefly, in the face of COVID-19 pandemic, the government has taken steps to ease EI requirements to account for the fact that many individuals would not otherwise have sufficient insurable hours during their claim period. And in conjunction with the end of the CERB, the federal government has introduced 3 new recovery benefits to replace the CERB. Next slide, please. So the CRA will be responsible for administering the new benefits, and eligible Canadians will be able to apply through the CRA. The first benefit, the CRB, Canada Recovery Benefit, will be effective from September 27th for 1 year. The CRB will pay workers who are not eligible for EI up to $400 per week for up to 26 weeks, and the payment will be taxable. Please refer to the link, the October 19, 2020 FTR Now for the eligibility criteria. I will say further to this point that individuals will need to reapply every 2 weeks and each time confirm that they continue to meet these requirements, including that they are looking for and will accept work when it is reasonable to do so. Individuals receiving the CRB will be able to earn income from employment and or self-employment while receiving the benefit, but that will be subject to a clawback of 50 cents each dollar. Again, more information on that at the link provided there. The second benefit that we will discuss is the CRSB. The CRSB will pay $500 per week, which is also taxable, for up to 2 weeks from September 27th, 2020 for up to a year. The CRSB will be available to workers who miss a minimum of 60% of their scheduled work in a week because they are sick or must self-isolate due to COVID. And there's also eligibility criteria for the CRSB, which can be found at the link. And the last one here is the Canada Recovery Caregiving Benefit. The eligibility criteria for this one is a bit more complex, so please do refer to the link to see whether the individuals who you're contemplating are eligible. The CRCB will also be effective from September 27, 2020 for 1 year and will pay $500 per week, again, also taxable, for up to 26 weeks per household. Individuals would apply after each week for which they are seeking income support, and 2 members residing in the same household can be or cannot be in receipt of the benefit for the same time period. Next slide, please, Steve. So now turning from the benefits to some federal subsidies for businesses. Bill C9 and Act 2 amend the Income Tax Act introduced a couple of new changes to the CEWS and the CERS. The CEWS, Canada Emergency Wage Subsidy, was extended until June 2021, and it remains at the current rate of 65% of eligible wages until December 19th, 2020. The government, the Department of Finance of Canada, will be releasing backgrounders regarding the CEWS, and will give additional details on possible extensions and also details on eligibility. We have covered what has been discussed so far in our October 16th, 2020 Hicks Morley FTR now. Some of the topics that will be included in that article involve active employee subsidy rates fixed for CEWS claim period 8, 9, and 10. So basically, a determination of the wage subsidy for active employees will currently in effect will remain unchanged until mid-December. Another topic discussed is a top-up subsidy determination, so change the qualifying revenue decline test. And the third will be for furloughed employees and individuals who are on leave without pay, and that would be a determination of the subsidy to be aligned with EI benefits. So moving now to the CERS, the Canada Emergency Rent Subsidy. This subsidy provides relief in respect of rent and interest on debt obligations incurred to acquire real properties by businesses, charities, and not-for-profit organizations in the course of their business and other activities. The rent subsidy is in effect from September 27, 2020, and these measures are designed to help businesses get through the second wave of the virus so they can continue to protect jobs, serve the communities, and be positioned for strong recovery. Now, until June 2021, as per Bill C9, the rent subsidy will be provided directly to tenants. Property owners will be given mortgage support, and there is a new lockdown support, which involves a top-up of the Canada Emergency Rent Subsidy of 25% for organizations temporarily shut down by a mandatory public health order issued by a qualifying public health authority. And this would be in addition to the 65% subsidy from CEWS. So combined, this would mean that hard-hit businesses subject to lockdown could receive rent support up to 90%. And another component of the CEWS is that it expanded the Canada Emergency Business Account, which would enable businesses and not-for-profit organizations who are eligible for interest-free loans. And the deadline to apply has been extended to December 31, 2020. So now to move on from the federal to the provincial. Employment is governed by provincial and not federal, as I'm sure many of us here are aware. Though as we discussed, one can be accessing a federal benefit such as a CERB, CRSB, or CRCB while off on a provincial leave of absence. And specifically, we will discuss the DEL, IDEL, and deemed IDEL. Short forms, long forms are on the screen, as you can see there. So moving to the infectious disease emergency leave, Bill 186 has created a new leave of absence entitlement related to infectious disease emergencies. It amends the leave of absence provisions already in the Employment Standards Act to provide more leave entitlements to employees impacted by the pandemic and to prohibit employees from requesting medical notes in relation to the new leave. We'll discuss this more later. These amendments are retroactive to January 25, 2020. In our FTR now, as you see on the screen of March 17th, 2020, we reviewed the impact of the declaration of a state of emergency in Ontario and the triggering of the declared emergency leave under the ESA. And one thing to note, just like other leave of absences under the ESA, both these leaves, the DEL and the IDEL, are job protected. Some common requests for leave include the employee is in quarantine or isolation, is subject to a control measure, is providing care or support because of a matter related to COVID, and school and daycare closures. Further, the infectious disease emergencies apply where the government designates an infectious disease by regulation, and an employee will not be performing work for one or more of the following reasons in relation to the designated infectious disease. I won't take up time by going through the list you see on the slide before you, but suffice to say that given the broad categories above, it is clear that the government intends the new leave to protect a wide range of employees whose ability to attend at the workplace has been impacted by the current pandemic. The new leave is unpaid. It It is designed to last as long as the COVID-19 remains designated by regulation and the employee is unable to work because of the reason engaged by their circumstances. More on this because of when we get to Steve's portion of the presentation. But this last point means that the new leave could apply for quite different periods of time. So an employee who self-isolates for 14 days and then is able to return to the workplace could have a very different length of leave than somebody who is unable to return to Ontario because of travel restrictions. Of particular note, employers can require evidence reasonable in the circumstances at a time reasonable in the circumstances to verify the leave. Note that the addition of the idea at a time reasonable in the circumstances indicates that there is some flexibility to be given to employees taking the leave and to provide evidence to the employer. So some IDEL scenarios before you here will be discussed by Steve during his segment of the presentation. Moving forward to the deemed IDEL. As I'm sure most of us are aware here, recall that the ESA designates a temporary layoff as 13 weeks and 20 or 35 and 52 with benefits or payments. Thousands of employees, non-union employees, were laid off in March from the shutdown and were going to be deemed terminated unless something was done. So instead of extending the temporary layoff in the ESA, the government chose to move all employees retroactively onto the IDEL. And this is why it's a deemed IDEL. Rather than being terminated, they were deemed to be on infectious disease emergency leave, at least under the ESA. Issues do remain in relation to whether constructive dismissal applies under the common law. But as far as the ESA, constructive dismissal and layoffs are addressed, as we will get to. Originally, this was to end, the deemed IDEL was to end on September 4th, 2020. But on the afternoon of September 3rd, it was extended to January 4th, 21. As a result of this extension, the status quo will remain in effect until at least January 2nd. The first relief measure of the IDEL regulation is the creation of a category of infectious disease emergency leave. The IDEL regulation deems an employee to be in this new category, on this new category of leave, where they do not perform their duties because of their hours of work have been temporarily reduced or eliminated because of COVID-19. The deemed IDEL, favorable to employers, assists those whose businesses remain closed or operating at less than full capacity due to the ongoing effects of the economic downturn. And employees are deemed to be on this IDEL, so they're deemed not to be on layoff or not to be on constructive dismissal, which we will get to during the COVID-19 period, which as of right now is slated to end on January 2nd, 2021. So employees deemed not to be on layoff. This is the second key relief measure of the IDEL regulation, and it relates to non-union employees whose hours of work have been reduced or eliminated, or whose wages have also been reduced for reasons related to COVID-19 and during the COVID-19 period. For these employees, the IDEL regulation provides that the ESA's usual termination and severance rules related to layoffs do not apply, and the employees are effectively deemed not to be on layoff for the purpose of the sections of the statute. And again, these provisions are in place till January 2nd, 2021. Now, with regard to benefits, the usual protections apply with some modifications. As employees are deemed to be on an ESA leave of absence, the IDEL regulation provides that the ESA's usual protections apply. However, there are important modifications to the requirements, particularly with regard to benefits. If an employee had stopped participating in a benefit plan as of May 29, 2020, the employee no longer has a right to continue participating in the benefit plan during the COVID-19 period. Similarly, if an employee had stopped its contributions as of May 29, the employer is not required to make any contributions to that benefit plan during the period. However, for those employers who have continued the benefit plans after the May 29 date, it appears that they would be obligated to continue the benefits continuation or the benefit contributions. This is important for employers who had temporarily laid off employees without continuing the benefit plans, as employers would be relieved. But please do note that if you had continued benefits after that date and the employee continues to pay their portion, if it's a dual plan, then the benefits must be continued through the period. So some few final notes on the deemed IDEL. The IDEL regulation makes it clear that the new rules also apply to assignment employees who are employed by temporary help agencies. It also provides some guidance on how to determine if an employee's hours of work or wages have been reduced. In brief, employees with a regular work week, the default comparator will be the last regular work week. And for those without an irregular work week, it will be the average of the 12-week period preceding March 1st. The IDEL regulation also provides that certain complaints filed with the ministry alleging that a temporary reduction or elimination of hours of work or a temporary reduction of wages constitutes termination or severance are deemed not to have been filed if the reductions were made in response to the COVID-19 pandemic period, or during the COVID-19 period, excuse me. This rule is quite technical and has a number of exceptions, so employers should be sure to consult the text of the IDEL regulation and of course seek legal advice if you have received a complaint under the ESA, which myself, Stephen, and anyone at my firm would be more than happy to assist with. So there are exceptions to the deemed IDEL. Two key categories of exceptions are as follows. The first will apply if at any time on or after March 2020, the employer takes steps to terminate the employment relationship. This could occur where one of the three things on the screen happens. And again, this presentation is being recorded, so we can always refer back to the presentation. And the second category will apply if before May 29, 2020, the employee had already been deemed terminated, as we see on the screen, or severed under the ESA as a result of an earlier layoff or constructively dismissed and had resigned within a reasonable time. In all other cases, non-union employees whose hours of work have been reduced or eliminated as a result of COVID-19 are now deemed to be on an IDEL for the duration of the COVID-19 period. So returning for a second to deeming employees not to be on layoffs, there are two key exceptions to this rule where employees will remain subject to the ESA's usual layoff rules. The first is if an employee was laid off as part of a complete closure of a business, they will be treated as been having terminated and severed under the ESA rules. Second, the new rule deemed IDEL will not apply if before May 29, 2020, the employee's employment had already been deemed terminated or severed under the ESA as a result of an earlier layoff. The final component of the IDEL regulation relates to constructive dismissal, and it deems certain actions of the employer made in response to COVID-19 not to be a constructive dismissal if they were made for reasons related to COVID-19. These provisions, again, will apply during the now extended COVID-19 period until January 2nd, 2021. The IDEL regulation only amends ESA rules related to layoffs and constructive dismissal, and the interaction between the IDEL regulation and the common law, so what a judge would decide, remains untested. Thus, we continue to encourage employers to seek legal advice before undertaking reductions in hours or wages in relation to your employees. Unless further extended, the COVID-19 period is slated to come to an end on January 2nd, 2021, at which point the usual ESA rules related to layoffs and constructive dismissal will be re-engaged. Employers who are not able to fully resume operations by that time will therefore need to carefully consider how they will address the ongoing employment issues. The IDEL regulation amends the ESA related to layoffs and constructive dismissal, but again, it is unclear what impact they may have on the common law, and it would be prudent to seek legal advice from your friendly Hicks Morley lawyer. So the deemed IDEL and the IDEL, layoffs and constructive dismissal protections may come to an end with the deemed IDEL, but the IDEL will not necessarily end, as it is tied to the designation of COVID-19 as an infectious disease emergency leave. So as we've discussed briefly prior, there is job protection with these ESA leaves. Employees entitled to return to the same job or one comparable to it if that job no longer exists unless the employer can demonstrate that that job would have been eliminated regardless of whether the employee went on leave. Though this is typically a high threshold and can be a tough inference to rebut. We also want to flag for you issues with regard to vacation deferral under the ESA. The vacation time earned for a vacation entitlement year or stub period must be taken within 10 months. We are aware of this most likely. And the employer has a right to schedule a vacation as well as an obligation to ensure that vacation time is scheduled and taken before the end of that 10-month period. However, if the deadline under the ESA for taking a vacation comes up when an employee is on an ESA leave, for example, a declared emergency leave, the vacation must be taken when the leave ends or at a later date with the agreement in writing. This means that it doesn't just evaporate to thin air. Their vacation will be resumed or will be able to be taken after they resume their employment. So even if an employee's contract requires some or all of their vacation be taken within a specified time period that comes up while they're on leave, and the employee would otherwise have to give up some or all of their vacation entitlement, the employee may defer taking their vacation until the leave ends or at a later date. And lastly, it would appear that employees who receive paid vacation time, which has not been taken and or paid out prior to the employee taking the ESA leave, similarly will roll over in accordance with Section 51(1) of the ESA. So before I turn it over to Steve, we'll just quickly discuss WSIB claims and also some issues under the Occupational Health and Safety Act. Like all potential workplace injuries and illnesses, to be entitled to benefits, the worker must establish that the COVID-19 arose out of and in the course of employment. There is currently no presumption that because an individual contracted COVID-19 that they are entitled to WSIB. So how is this determination made? Well, decision makers will determine if a COVID-19 case gave rise to WSIB benefits by looking at each case individually on its own merits. However, two things that they must consider is one, whether there was enhanced risk in that specific workplace, and two, whether the worker actually got COVID-19. This second criteria would probably have been a bigger issue back in March before testing was readily accessible, though with the restrictions on testing that came out maybe about a month ago, it may similarly be difficult to get a test in the required timeline. Moving over to Occupational Health and Safety Act, COVID policies are required to the extent that an employer has an obligation to take every precaution reasonable to keep its workers safe. To this end, one should follow the guidance of provincial health authorities. Having applicable policies posted and available is important, of course. Now, the first wave of COVID-related complaints concerned issues we would expect, such as non-compliance with OSHA by failing to provide PPE, whether employees were self-isolating, whether they were entitled to sick pay under the benefit policies, and whether employees were required to report employee COVID-19 cases as occupational illnesses. Along with general complaints, employees may receive outright work refusal under the OSHA section 43.3. I won't read through the provision here for you, but workers may refuse to do particular work where they have reason to believe that such like equipment or the condition of the workplace or workplace violence is an issue. To this end, the Ministry of Labor will be assessing claims made under the Ontario Occupational Health and Safety Act in every case. And what they will be seeking to determine is whether the employer had taken all reasonable precautions. And this would include things such as screening, whether staff has been asked if they've been traveling, whether they've been asked if they're showing symptoms, whether the public is allowed on the premises and what communications have been given in that regard, social distancing, things of that nature. And now also separate and apart from claims made under the Ontario Health and Safety Act, employees may refuse to come to work citing not safe as a reason, which doesn't meet the criteria for the ESA leaves as there's no shortage of work, no COVID cases in the workplace, and section 43.3 of the OSHA is not cited. Our firm has discussed taking a few positions when employees refuse work under these pretenses: 1, discipline due to insubordination; 2, abandonment of employment subject to the applicable policies; 3, we may advise the employee that they are absent without leave, but not to the extent that they have abandoned their employment. That's generally a fairly high threshold to meet. And the 4th is to place an employee on some unpaid non-ESA leave. Of these 4 options, it may be best practice to do option number 3, which is to advise the employee that they are absent without leave. This would leave the door open for discipline if the situation does not resolve itself, while also creating a paper trail that will likely be helpful if and when related disputes arise. And lastly, before I turn it over to Steve, on the point of accommodation, it appears that employers cannot ask for medical notes from employees and customers/clients who claim a disability preventing them from wearing a mask. But employers do have a duty to accommodate if a medical reason is cited by the employee. So we can try to coax them through progressive discipline, but we cannot force them to wear a mask. And with that, I will turn it over to Steve.
Thanks, Evan. Evon, sorry, I didn't mean to clear my throat. My microphone was turned back on. So what I would like to go through, and I think we're going to answer the questions once we're done the presentation. If you've got any questions, as Ryan said, put them in on the Q&A section. What I'm going to go through is what employers have been dealing with in the current circumstance, and maybe more so, unfortunately, in the last month or so, with employees coming back to work. And what can employers do dealing with some perhaps difficult circumstances with the employees? So some of what we have seen is an employee says, perhaps I have a condition related to COVID that exposes me to increased risks, and I shouldn't come to work. And as Evon said, the problem is employers are prohibited from requiring an employee to get a medical note. What the Act does say is you could ask for information reasonable in the circumstances to justify the leave, but we can't ask for medical notes. What some employers are doing, as another example, is with employees saying, I can't wear a mask, whether or not we could ask for some medical regarding how we could accommodate a medical situation that's preventing the employee from wearing a mask. But unfortunately, Employment Standards Act says we cannot ask for the employee's medical note. If the employee is saying that, for instance, a person I live with has an immunocompromised condition, we might be able to ask for some information with respect to that individual. But again, I don't think we can ask for medical information. So what about, we've also had situations where employees, even during the current circumstances, have decided they want to go to Europe and visit their family. What can we do about that? I think our view of it is if that employee chooses to go, they would be entitled to the infectious disease emergency leave when they come back, because of course they're going to be required to quarantine. Some employers, and this is perhaps a bit of an assertive approach, some employers have decided, I'm going to have a rule saying that if you travel and cause yourself to have to take a 2-week quarantine after you come back from your 2-week vacation, you will be subject to discipline. But I would caution that's a bit of an aggressive approach, perhaps, because you may wind up getting a complaint that that's a reprisal for the employee taking the leave. So I think you should be careful if an employer was going to take that approach, and perhaps talk to one of us before we implement that. So I think Evon made the point, and I wanted to make it clear again, that there's a causation between the employee saying they want to be off on the IDEL for specific reasons, and it has to be related to the infectious disease. So if an employee, for an example, if an employee lives with a family member who has a medical condition that makes them at higher risk for COVID. It could be diabetes, high blood pressure, other immunocompromised situations. That individual may not be entitled to the leave if they say, I shouldn't be working because I could expose that person. But if they're not providing care or support to that person because of the leave, then the ministry would likely take the position, the Ministry of Labor, that they would not be entitled to the IDEL. So the individuals need to be providing care and support, and not only providing care and support, but it needs to be because of the current pandemic, the infectious disease. So what are some of the other examples? One that's, and this is perhaps why the government is trying hard not to close schools in Ontario, but the specific provisions of the IDEL, I think when you look at what Evon put up on the screen, the closure of daycares and schools, childcare are clearly an entitlement to the IDEL. So if the employee's school is closed or their daycare is closed, that would give rise to them having the ability to claim a leave under the Employment Standards Act. There's perhaps an even more concerning position of the Ministry of Labor, and they have a policy, somewhat 1,300-page policy and interpretation manual, and they've updated that with respect to these new leaves. And one concerning point in there is that they've said, if the parent says, I'm afraid to send my child to daycare because I've got concerns that they might get exposed to COVID, the ministry views that as being a valid entitlement to taking the infectious disease emergency leave. So I think you need to be careful looking at each situation and understanding exactly what the circumstances are, so we could make a decision as to whether or not the Ministry of Labor likely is going to think that that person should be entitled to take that leave. Certainly, you need to be careful if you're going to discipline or even terminate somebody under those circumstances. We would want to make sure we're on the right side of what the interpretation is likely going to be. Another point that I think we want to talk about is there's an overlap between the Employment Standards Act, but also the Human Rights Code. There were quite a bit of increasing claims over the last few years about family status, people having conflicting family responsibility, conflicting with work, and which had to give way to which. That, as we have seen that becoming increasing even before COVID-19. You're also going to see more of that with COVID-19, because obviously what was available to somebody in terms of alternate childcare might not be available anymore because of restrictions due to lockdowns and other concerns. Elderly parents or grandparents that might have been able to help with childcare may not be able to do that at the current time. The other thing you've got under the IDEL and the issue with the pandemic is immunocompromised employees and their family members and other medical disabilities. And there, of course, is an element to that that was always there to do with the Human Rights Code, in terms of an employee saying, my spouse is extremely ill and I need to care for her. The Employment Standards Act looks at these things, but we also have to consider the Human Rights Code. So keep in mind, under the Human Rights Code, there's a duty to accommodate to the point of undue hardship. So there is an obligation on the employer to try and accommodate to the point of undue hardship, and it's to enable the employee to fulfill the essential requirements of the job. And so you will need to consider what are the essential duties of this position, and how do we find a way to enable the employee to be able to do the job. And employees are, I've said it before, they're not entitled to perfect accommodation, and they don't necessarily get to pick the accommodation, but we are obligated to try and find a way to accommodate either their family status issue or the issue arising out of their medical disability. It's also important to remind us that there's a procedural requirement and a substantive requirement. So it's the two pieces. If you could substantively accommodate or not be able to, but if you didn't follow the procedure and the process and document it, the Human Rights Tribunal may say there's still a breach of the Human Rights Code. So on the screen, you'll see there's a graph of sort of outlining the procedural aspect of this. And basically it's our obligation, the employer's obligation, to get information from the employee so that you can inform yourself and assess the situation and then investigate a way to try and address those needs to enable them to perform the essential duties. And that's an ongoing process that you have to look at. Now, I would just on the accommodation part make it clear that that is, I always want to point out, a two-way street, that employees have a duty under the code to cooperate with your efforts with respect to accommodation. So family status, this has been fairly common, as I said. There's another slide I'm going to get to in a minute that talks about the kinds of things that we should have been looking at when we want to engage the employee in that accommodation process. In the current situation, another thing you might not have thought about is that they've amended the Education Act, and sometimes we had employees who claimed family status accommodation because they chose to homeschool their children. And the analysis would have been, well, that's a choice of yours. You don't have to do it, so we don't necessarily have to accommodate it. And in the current situation, the problem is they've amended the Education Act to allow students to stay at home. And I think if you look at the ministry's policy that I talked about earlier, and the fact that people are now free to say, I don't want to send my kid to school because they might get COVID, that will give rise to a family status issue. So what are some of those questions that employers should be asking? And this would have been a slide we would have presented about family status before COVID-19. So the employee is under an obligation to try and find alternative methods or means to find childcare, whether it would have been family members or would have been a different daycare and things like that. As I said before, it's going to be much more difficult now for that employee to find other options. And that may mean that we can't find a way to enable them to be able to come to work, or it may be very clear already that they are under the IDEL because of the closure of the daycare, for instance. So the other issue is to do with the immunocompromised employees and family members. If you go back and look at the slide that Evon presented, if you're under a direction by the Ministry of Public Health, the government, there's a list there of organizations that if they are advising you, you shouldn't be at work. You could ask the employee to go online and complete the government's questionnaire there. And if the employee enters certain medical conditions, that is going to probably generate a response that says they should self-isolate, which would then entitle them to the IDEL. And it also would trigger the duty to accommodate under the code if they've got a disability, which may mean looking to whether there's ways to enable me to come to work, assuming I'm not going to ask for the IDEL. Could you change my job? Could you change my work location so I don't have to come into contact with other people? There may be various steps you could take to enable me to still come to work and accommodate that situation. So there are situations as well. We just want to say it's not a very often used section of the Human Rights Code, but there is a section that says you can't discriminate against me because of my association with someone who's in a protected ground. And so that is something we do need to consider, where employees are saying, I live with somebody who's immunocompromised. So we do need to walk through that and consider, and again, it is dealing with each individual circumstance. I'm just going to go quickly through this Waksdale case. Maybe you want to call it wacky, but I'll tell you basically what happened in a nutshell is, and this is a risk. This case is very important because it almost probably strikes down a lot of termination clauses in most of your employment contracts, especially those that have an ESA only provision. And really what happened is the contract had, I can terminate you for cause, or I can terminate you without cause and give you this. And whether that is ESA or something above that, it's still going to be the same issue. The court basically concluded that because the Employment Standards Act doesn't say the word cause anywhere, it says you don't get your termination and severance pay if you are guilty of willful misconduct or disobedience, neglect of duty, that's when you lose your entitlement under ESA. And it's been recognized that the difference between that and cause, there is a difference. And because there could be situations where it might be cause to terminate me, so I don't get my common law or my ESA under your contract, but it might not have been willful misconduct, disobedience, or neglect of duty. So I still should get my employment standards, but not my common law. And really it's, you might argue, splitting the hairs, but that's why the court said, well, that clause is not valid. It disentitles him to his ESA when he should have had it. And the problem with it, this case, was the employer said, well, that's fine, sever that part, and the other part of the clause should still stand. And the court said, no, the entire termination clause is gone. So what does that mean? It means, I probably have said this to you before, I don't know who's in the room, but you need to go and look at your contracts. And if you've got termination clauses and you want them enforceable, you're going to have to revisit them yet again. I would say that Waksdale case is before the Supreme Court. We don't know yet whether or not the court's going to grant leave to hear the appeal. But the types of things that we've seen in contracts where people have tried to put employment standards only clauses in, if they didn't refer to benefits during the statutory notice period, then it was void. If it didn't expressly say severance pay also, void. If it tried to combine notice and severance and it said, I could give you working, I could pay that as working, or I pay it in lieu, void, because you can't work out the severance portion of that. So you have to be very careful with that. If you're doing above employment standards, you might want to consider putting in a mitigation clause, which means if you get another job, then it reduces or stops the payments I owed you. Keep in mind that employment standards cannot be reduced because of mitigation if the person gets another job. But if you put in a clause that says I get a 12-month termination package, you would want to put in a mitigation clause saying what happens if I get another job, because if you don't, then I still get 12 months and I landed a job the day after I left. The other one that's pertinent with COVID is layoffs. Most employment contracts don't talk about layoffs, and Evon's going to talk about this quickly next, is if you the law has for a long time said that you don't have an automatic right to lay off for a common law person. So the contract was, I come to work, you pay me, and I do my job. And there was nothing to say you could send me home for 2 months without pay. Doing that under the common law would have been a constructive dismissal, unless you've got something in your contract or a practice or a policy, perhaps. So there is no implied right. Most employers now, after COVID and the situations we have, are looking at putting in some kind of layoff clause. So you should consider that as another element of reviewing your contract clauses. So I think the key takeaways for your contracts, issues with COVID, et cetera, and this new Waksdale case is you need to look very carefully at the wording. Obviously, plaintiffs, lawyers, and the judges are going to pick it apart. And if there's a thread there, they're going to pull on it. And judges, it seems, want to find ways that remove an employer just giving ESA instead of the common law. So you should be making sure you're looking at those contracts and considering those issues that I've just talked about. So I'll just hand it back to Evon to talk a little bit about, well, what are we seeing in the courts so far resulting from all of this situation we're in with COVID?
Thanks, Steve. So very briefly, as Steve mentioned, at common law, the concept of layoff does not exist. While employment standards legislation may address temporary layoffs, it does not grant employers the right to impose them unilaterally. These things must be baked into the contract. Employers can mitigate the risk associated with temporary workforce reductions by reserving the right to temporary layoffs in their employment contracts. An employee who chooses to resign and treat the layoff as a constructive dismissal is ending the employment relationship. And it seems unlikely, given the current economic circumstances, that most employees could reasonably expect to obtain new employment, though this does differ depending on the industry. Nevertheless, we are seeing constructive dismissal claims brought by employees who generally actually have no interest in continuing employment. Rather, they seem to be using temporary layoff as a mechanism to receive a payout. We've seen constructive dismissal claims from employees otherwise contemplating retirement, who likely view it as a bonus, and also employees who are contemplating career changes. So what are some potential defenses to such claims? The common law applies certain terms into an employment contract, such as common law reasonable notice. One potential legal position when faced with temporary layoff, constructive dismissal claims, is that courts ought to recognize as an implied term in the employment contract the ability of employees to temporarily alter terms and conditions, particularly in a global pandemic, as the economic circumstances are dire and health and safety concerns are high. Another position we have been taking is that the ESA provides employers with a right to temporarily lay off employees. The ESA specifically states that a reduction in hours due to COVID is deemed to be an idle, as we've discussed. Our position has been that the ESA must give employers a right to implement these layoffs. Otherwise, we're left in a situation where there's a right to, or we're left in a situation where an employee is constructively dismissed at common law and entitled to seek damages, but not constructively dismissed under the ESA. Another position we've been taking is the common law concept of frustration, which basically says that due to unforeseen and uncontrollable external events, compliance with the contract has been rendered impossible. So moving to the last slide here, some things that we can do to limit damages in constructive dismissal claims are a failure to accept recall or a failure to accept employment on modified terms and hours may represent a failure to mitigate damages on part of the employee. So we should consider offering employees a recall or alternative positions even after constructive dismissal has been assertive. And ultimately, this will help us lead evidence on when the employee should have been recalled. And it goes to limiting the damages which may be borne by the employer. So with that, I believe we are now at our Q&A period.
Yeah, thank you very much, Evon and Steve. I know we're a few minutes past our allotted time, so just ask a couple questions here quickly because I know people have other meetings to get to today. This first one is under IDEL. What happens if the employee does not pay their portion of benefits?
I can take this one, Steve. So I believe that if an employee stopped contributing as of May 29, 2020, they no longer have a right to continue to participate during the COVID-19 period, which ends at on January 2nd, 21.
Yeah.
Okay, great. Thanks very much, Evon. Steve, do you have anything to add there?
Yeah, and I'll answer the next question if you like, Ryan. I don't know if you want to read it, but just keep in mind the IDEL and the DEL went in the Employment Standards Act, and they're just two leaves amongst about 8 or 10. All those other leaves, pregnancy, parental, family care, all those leaves are all treated the same way with respect to the protections under the Act.
Thanks, Steve. What's the next question that you'd like to answer there?
So somebody's asked if the employee, sorry, I'll go back up. So that an employee in a patient care environment has to be close to patients but can't wear the PPE. Is there a duty to pay the person? So there'll be that'll be one of those situations you really have to examine the circumstances, because if it's a hospital or certain other types of operations, there are very detailed regulations and guidance that we would have to look at. It goes back to the Human Rights Code issue that I talked about, that you would have to go through that accommodation process and try to figure out and understand what's the restriction about the PPE. Why can't they wear it? We're not entitled to diagnosis, but maybe there's something they could wear instead that would still meet the requirements. It will depend. It could be the face shield, it could be something. But you'd have to look at the situation. If you can't accommodate somebody and you've done everything you can to try and find a way, and perhaps they could be moved to a different area of the operation where this isn't an issue, I don't know. But if there is no way to accommodate them, then no, you don't have to pay them. And that's really no different than if they would go on the IDEL and they would have access to some of the benefits that Evon spoke about from the federal government, perhaps. But no different than if I couldn't work because I broke my leg. You know, I might get LTD, I might get STD, but you don't pay me if I can't work, but you have to try and accommodate me. I guess, Evon, do you want to answer the next question?
Guys, I think we're just going to move to one more question here before we wrap up. And I'll ask it here to the both of you. If someone is a federally regulated company, are items such as IDEL and MOL applicable or not applicable?
I don't know what MOL means, but no, the IDEL, you'll have to go to the Canada Labor Code. The Employment Standards Act in Ontario does not apply to federally regulated employers. There's different provisions in the Canada Labor Code.
Okay, great. Thanks very much, Steve and Evon. Just because we're over time, we're going to wrap things up here. Thank you to both of you for sharing your valuable time and expertise with us. Just as a reminder to all those who are on, a recording of today's presentation will be made available early next week. Stay tuned to our LinkedIn page at NFP Canada, our website, nfp.com/Canada, and your emails for more details. As you can see, Steve and Evon's emails are up there if you have any further questions, and we'll try to get those answered for you. This was the third and final webinar of our fall series on key topics in the group benefits and retirement sector. Thank you to everyone who attended over the last 6 weeks. We really appreciate it. Once again, Evon and Steve, thanks so much. That concludes our webinar today. Thank you all for joining us and have a great day.
Thank you. Thank you, everybody.
Take care.